Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 68. In this podcast we're looking at three different cases. The first is one which looks at type 2 diabetes and whether the condition amounted to a disability under the Equality Act. Secondly, we have an EAT decision which considers unfair dismissal, wrongful dismissal claims and the different tests the tribunal had to apply in relation to each claim, and the extent to which an employer has to investigate misconduct where the employee has already admitted some wrongdoing. Lastly, we look at a tribunal decision on holiday pay and need to include commission payments when calculating an employee's entitlement to holiday pay. Having now made our way safely past April Fool's Day, I can disclose that we spent some time trying to work out if we could get a well-known politician onto our podcast series to talk about his employment programmes and employment law proposals following the general election. But sadly we couldn't work out how to get Al Murray, the pub landlord, who is of course currently standing against Nigel Farage, onto the podcast series to explain his employment policies, including that of withdrawing Britain from Europe by 2025 and the solar system by 2050. Unfortunately, the only connection we could work out was that my mother had gone to the same university as his mother, which seemed a little tenuous. Anyway, to business. So the first case, Metroline Travel Limited and Stout. This is an EAT decision which looks at whether or not type 2 diabetes constitutes a disability under the Equality Act, where the employee could control the condition through a sensible diet. I wanted to mention the case. It may help to explain why I thought this was a case worth flagging. Type 2 diabetes is not that uncommon, and this case has had a fair amount of publicity, and I think it's slightly misleading publicity. And thirdly, frankly, the judge was clearly enjoying himself on a couple of points when he wrote the judgment, as I shall explain. Section 6.1 of the Equality Act sets out the definition of disabled as a person who has a disability. A person has a disability if it has a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on his ability to carry out normal day-to-day activities. Substantial is considered to mean more than minor or trivial, and long-term means 12 months or more, or where the effect is likely to last 12 months. There are particular rules about recurring or fluctuating conditions, and some conditions are excluded altogether, alcohol addiction being one of the obvious examples. Under the Equality Act, employers are required to make reasonable adjustments for employees who are disabled. Brief facts are the case that Mr Stout worked as a bus driver for Metroline Travel Limited until he was dismissed for gross misconduct. It was noted both by the tribunal and the EAT that Mr Stout had a, quote, somewhat checkered employment history, including, according to the EAT judgment, diverting his bus so that he could go and buy some chicken kebabs. Sometimes you do have to love employment cases with snippets like that. Well, following his dismissal, Mr Stout claimed unfair dismissal, disability discrimination, and failure by Metroline to make reasonable adjustments. The relevance of Mr Stout's disability, or alleged disability, to the events in question was that he claimed the side effects of the medicine he was taking for his type 2 diabetes meant he was on occasions, quote, unable timiously to perform work, unquote. Well, the Employment Tribunal determined at a preliminary hearing Mr Stout's type 2 diabetes did result in him being disabled within the meaning of the Equality Act. In coming to its decision, the tribunal referred to a medical report which noted that there were 2 periods when Mr Stout was not taking medication to reduce his blood sugar levels. Mr Stout confirmed to the medical advisor that he was following a diabetic diet and avoiding sugary drinks. The tribunal judge referred to paragraph B12 in the guidance provided on the definition of disability coming from the Equality Commission. The guidance states that in respect of impairments that can be treated or corrected, they should be treated as still having a substantial adverse effect if, but for the treatment or correction, the impairment was likely to have that effect. In other words, you discount the treatment or correction. Likely in this case, as is well established, meant could well happen rather than more likely to happen. So the tribunal, the Employment Tribunal, had concluded that Mr Stout's diabetic diet amounted to a treatment or correction, and therefore his type 2 diabetes was to be regarded as a disability. Metroline appealed the tribunal's decision that he was disabled, and in the meantime, another part of the employment tribunal system, went on to dismiss his actual substantive complaints based on the finding that he had been disabled. And they said his dismissal did not constitute unfavourable treatment by reason of his disability. Both claims for unfair dismissal and discrimination arising from disability and failure to make reasonable adjustments were dismissed, and so he was now out of time to appeal that finding. So you could ask, what was the point in Metroline making this appeal on the preliminary issue to the EAT? Good question. Well, Metroline argued it had a workforce with a number of employees who suffered from type 2 diabetes, and it was concerned that the tribunal's decision could be relied upon by other individuals to bring parallel or similar disability claims. Metroline also tried to, in the words of the EAT, somewhat ambitiously, submit that the judgment is of public importance, a submission the EAT was quick to quash, concluding that whilst they were sure that the particular named advocates' cases were all of public importance, quote, in the great scheme of things, this particular case will scarcely ruffle the pages of the Willesden Gazette, unquote. Like I say, you've got to love employment cases sometimes. However, the EAT accepted there was a legitimate concern for Metroline in having this matter disposed of, came to the conclusion, very firm conclusion, the appeal was well grounded, and so allowed it to proceed to a substantive hearing. Well, the EAT upheld the entire appeal, concluding that the decision of the Employment Tribunal was perverse, and that the abstention from sugary drinks did not constitute a substantial adverse effect on day-to-day activities caused by the type 2 diabetes. In coming to this conclusion, the EAT agreed with Metroline that the Tribunal, although it had considered paragraph B12 of the guidance, did not refer to paragraph B7. B7 of the guidance provides that account should be taken of how far a person can reasonably be expected to modify his or her behaviour, for example by use of a coping or avoidance strategy, to prevent or reduce the effects of the impairment on normal day-to-day activities. Quote, in some instances, a coping or avoidance strategy might alter the effects of the impairment to the extent they are no longer substantial and the person would no longer meet the definition of disability. In the context of allergies, the guidance goes on to say that the day-to-day activity may be affected, and account should be taken of the degree to which a person can reasonably be expected to behave in a way that the impairment ceases to have a substantial adverse effect. Interestingly, the EAT judge disclosed that he himself suffers from type 2 diabetes, and he considered the condition had no adverse impact on his ability to carry out normal day-to-day activities. Although the judge did not refer to the paragraph in the guidance expressly, paragraph B14 of the guidance states that a particular diet may be discounted for the purpose of establishing whether, in the absence of a diet, the individual would be disabled if they suffer from type 2 diabetes. Here, ultimately, the EAT concluded it would be difficult to consider abstaining from sugary drinks to be sufficient to amount to a particular diet that amounted to a treatment or correction. The EAT held it would not be unreasonable for Mr. Stout to have stuck to his diabetic diet as a coping or avoiding strategy. That would prevent his impairment from having a substantial adverse effect on his ability to carry out day-to-day activities, and therefore he was not disabled. In other words, the requirement that he abstain from sugary drinks was not such an impairment that it rendered him disabled in the legal sense of the word. I think the case is a useful one for employers. It provides some helpful guidance on type 2 diabetes, whether the condition amounts to a disability under the Equality Act. It's also a helpful case for other conditions where some form of coping or avoidance strategy can be adopted to eliminate any substantial adverse effects the condition is having on the employee's ability to carry out day-to-day activities. Still, it remains prudent for employers not to assume that type 2 diabetes, or indeed other similar conditions, can never amount to a disability under the Equality Act. There was very little real evidence before the AT of the adverse effects of Mr. Stout's condition on his daily activities, and Mr. Stout was debarred from the appeal, so did not provide any further details on this. Perhaps, had there been more information provided on this, and whether the avoidance strategies were reasonable, he would have had been in a better position to show that he was disabled. The judge commented that the tribunal's approach would have necessarily meant that anyone suffering from type 2 diabetes controlled by diet was to be regarded as disabled. This would then have meant that people with, in his terms, nut allergies, intolerance to lactose, quote, or what have you, unquote, would also be regarded as disabled. I think this is really quite a difficult area, and as I say, if Mr. Stout had had the opportunity of being heard at the AT, maybe the outcome would have been different. And I think it would be completely wrong to rely on the judge's comments to assume that someone with, for example, a nut allergy could never be disabled. Final point I want to mention, and this is really just very briefly, it's the costs issue. I think it shows how far we've come on the issue of costs in respect to the AT's fees being payable by the loser. Mr. Stout was barred from attending the AT. The judgment doesn't say why. The tribunal judge had ruled in his favour. The appeal was described by the AT as not being, quote, entirely academic, unquote, and it was noted that it was for the benefit of the employer. The claimant's means were not available to the AT and so were not considered when it was debating whether or not to order the payment of the fees by him to Metroline for Metroline's successful appeal. Still, he was ordered to pay the fees of £1,600 under the AT's rules. And whether or not this is in strict compliance with the rules, really beside the point, it does seem to be a very unfair outcome. And it shows, again, how much things have changed in the tribunal system. So, that's the Metroline Travel Limited and Stout case. Next case, CRO Ports Limited, CRO Ports London Limited, I should say, and Wiltshire. This is an EAT case which considered admissions made by an employee during his disciplinary proceedings and the employer's subsequent reliance on those in dismissing him. It's not uncommon for an employee to make admissions during an investigative stage or a disciplinary hearing. Indeed, my own personal view is that where an employee is banged to rights on something, the best strategy for the employee is often to fess up, apologise profusely, and undertake that whatever the misbehaviour is will never happen again. Often it's a far better line to take for an individual than trying to defend the indefensible. But anyway, back to the case. By way of brief background, the Employment Rights Act 1996 provides the statutory framework for unfair dismissal, as we all know. Once an employer has shown that there's a fair reason for dismissing the employee, it's then for the tribunal to decide whether the dismissal is indeed fair. And coming to the decision, the tribunal has to consider equity and merits of the case, and whether the employer acted reasonably in treating it as a sufficient reason to dismiss the employee. And the well-known Birchall case sets out the fairness test for misconduct. The case of Croucher sets out that where the employee admits to the misconduct, an employer is usually exempted from carrying out an investigation in the light of those admissions. On remedy, in such circumstances where the employee is considered to have contributed towards the dismissal, the tribunal may make a reduction to the compensation to be awarded to the employee, if the dismissal is unfair, on account of the employee's contributory fault. In this case, setting out the facts briefly, the employee, Mr. Wiltshire, was a long-standing employee. He'd been employed as a supervisor for CRO, and prior to the misconduct had a clean disciplinary record and was considered to be a loyal as well as a long-serving employee. At CRO, large ship containers are moved by securing the corners of the containers to a crane using a locking mechanism. The locking process could be interrupted by a sensor, which detected that the steel pins in the corners of the containers were wearing down. However, it was possible to override this by putting a small piece of rubber or wood on the pin so the sensor wasn't activated. To deal with the sensor in the correct way would have required additional workers and time, and so the claimant asserted that this workaround process was something that had been operated tacitly at CRO for many years, and without incident, and with managers turning a blind eye. Well, you can work out what happened, can't you? In this case, there was a problem lifting a container. The manager asked Mr. Wiltshire to go and get a heavy-duty twist lock from the engineers to resolve the non-locker problem on the container. Mr. Wiltshire had never heard of such equipment and decided to first go and see what the problem was with the container. Pausing there, I did consider putting a picture of a heavy-duty twist lock on our YouTube version of this podcast, available via Mayor Brown-UK Employment Law on YouTube, so as to encourage traffic to our YouTube version of this podcast, but the compliance gnomes told me not to be so silly. Anyway, back to the story. When Mr. Wiltshire got to the container, he saw the team leader adopt the workaround and place a piece of wood on the pin to effectively disable or confuse the sensor. The light went green. Crane driver tested the container was locked on, which it appeared to be, and then lifted it off the ground. Since the crane could clearly lift the container, Mr. Wiltshire didn't go and say to the engineers to go and get the heavy-duty twist locks. But about 20 feet off the ground, the container fell from the crane. The container was damaged. Fortunately, there was no one underneath, but it would have caused a fatality if it had landed on someone. Well, both Mr. Wiltshire and the team leader were immediately suspended. And although Mr. Wiltshire appreciated the seriousness of the incident, he felt that as the practice was one that had long been condoned, he asserted, by CRO, combined with his clean employment record, he'd be reprimanded but not dismissed. So accordingly, he took full responsibility for the incident, he said, retrospectively. CRO undertook investigation and then conducted a disciplinary hearing with Mr. Wiltshire. During the disciplinary, he admitted that his failure to get the twist locks had been a dangerous act. Relying on this admission, CRO summarily dismissed him by reason of gross misconduct. Despite the suggestion the practice had been going on at CRO for a number of years, the disciplinary officer felt that Mr. Wiltshire was to blame for not reporting or stopping it. Mr. Wiltshire appealed the decision, but the appeal was dismissed, following which he brought claims of unfair dismissal and wrongful dismissal against CRO. Well, the Employment Tribunal upheld his claims and said there was no contributory fault. Bold decision. Having referred to the guidance in Birchall, the tribunal held that there had not been a reasonable investigation. The tribunal said that CRO should have identified the considerable pressure under which the operatives were working, that a reasonable investigation would have taken into account Mr. Wiltshire's actions were in CRO's interest, not his own, and additionally the tribunal concluded that the tone of the investigation created a climate of fear which impacted on the honesty of the responses that were given by the investigation. The tribunal felt that CRO should have taken steps to address this. The tribunal also highlighted the lack of any specific health and safety advice to deal with this issue. So for these reasons, they held there had not been a reasonable investigation and the dismissal was unfair. The tribunal felt that, in addition to there not being a reasonable investigation, CRO had failed to identify that the practice was clearly of long-standing, and this workaround, this unlawful workaround. And although Mr. Wiltshire had not helped himself in the internal investigation, it was felt by the tribunal this was explicable, given his loyalty and trust in CRO. The tribunal felt that the failures of the investigation were not put right at the appeal stage, and therefore his claims were upheld. And as I say, made no reduction for contributory fault. Well, not surprisingly, CRO appealed to the AT, and they did so on three grounds. First, that the tribunal had failed to correctly assess the question of contributory fault in respect to the unfair dismissal remedy. Secondly, and thirdly, they had applied the incorrect legal tests in relation to unfair dismissal and in relation to wrongful dismissal. Well, as I say, the appeal was upheld. The AT concluded, first of all, that the test applicable to an unfair dismissal claim required the tribunal to look at what the reason for dismissal was. Following this, the tribunal needed to consider CRO's investigation and whether its decision to dismiss Mr. Wiltshire was within the range of reasonable responses of the reasonable employer when it had limited its investigations due to his admissions during the process. Well, the AT concluded the dismissal was within the range of reasonable responses and that the Employment Tribunal had not been entitled to substitute its view for that of the reasonable employer. Given Mr. Wiltshire's admissions, it was hard to see, the AT said, how CRO's actions fell outside the range of reasonable responses. And the AT held that it was unnecessary, in the light of his admissions, to carry out further investigation and that the tribunal had failed to appreciate the significance of his admissions. In respect to the unfair and wrongful dismissal liability, the AT concluded that the tribunal had failed to distinguish between the task on the wrongful dismissal claim and that on the unfair dismissal claim. In the wrongful dismissal claim, the breach of contract claim, the AT held that the tribunal had had to make its own findings of fact as to what had happened and as to Mr. Wiltshire's culpability. Given that the tribunal had failed to separate out the findings and the different approaches relevant to wrongful dismissal and unfair dismissal, the AT overruled that part of the decision and sent it back for appeal too. The appeal on contributory fault, where the tribunal had found he had not contributed in any way to his dismissal, was also allowed on the grounds the tribunal's findings were perverse, not entirely surprisingly, although the AT was quick to say that they were not necessarily assuming that there would be any predetermined outcome when the matter was referred back to the tribunal. Interestingly, however, on contributory fault, the employer ran the argument that the admissions by themselves were contributory conduct. The AT held the Employment Tribunal had considered this point, and so the appeal purely on that point was not successful. But it does flag up an interesting point that if the employee makes admissions, which they subsequently try to go back on, an employer might well be able to rely on the original admissions as contributing to the dismissal. Clever point. I wanted to add the case to the podcast because, as I say, it's relatively common for employees to make admissions in some respect during disciplinary or investigatory proceedings. Equally, however, it's quite common that further on down the road, when attitudes have hardened, maybe advice has been taken, these admissions are either retracted or qualified out of existence. I think the best advice I can give to employers in a situation where admissions are being made is that if they're being made during investigation or disciplinary proceedings, it's always a good idea to check exactly what the employee is admitting to and why, and the consequences of that admission. It will make it much more difficult later on for the employee then subsequently to qualify or retract those admissions. Here, for example, the employee made admissions and the question was whether there was still enough that required further investigation. For example, the extent to which he was saying that what was happening was common practice, because that could have been relevant, I suppose, to how dangerous was this practice if it had been going on for 20 years and it had been done 100 times every year. I'm making that up as an example. But also the extent to which it had been condoned, and he was applying wrongly a practice that had been condoned by management. In fairness to the employer, I should point out that they did do an investigation into that at the appeal stage and retrieved some evidence which indicated the practice was nowhere near as widespread as was being asserted, although the employee claimed that was due to the culture of fear that the Employment Tribunal referred to. Well, the key point is, ask yourself, in the light of any admissions, are there any points that do still require an investigation sensibly, rather than just pouncing on the admission? So, overall, that's CRO Ports, London Limited and Wiltshire. Last case, Lock and British Gas Trading Limited. And you knew we were going to come to this case, didn't you? Well, this is the widely reported Employment Tribunal decision, which looks at the much-discussed topic of holiday pay entitlement, and this is the inclusion of commission payments in respect of holiday pay calculations. The Lock case was heard before the ECJ last year, and then had to go back to the Employment Tribunal to determine whether the Working Time Regulations 1998 can be read in conjunction with the relevant EU directive and the ECJ's judgment under that directive for Mr. Lock. Well, take a step back. To implement the Working Time Directive into domestic law, the UK government introduced the Working Time Regs, which deal with a number of matters: maximum working time, rest periods, annual leave, etc. In the Lock case, at the ECJ level, the ECJ established that under EU law, a worker's holiday pay, covered by the Working Time Directive, should be calculated to include salary and commission payments, and not just basic pay, where those commission payments are, quote, intrinsically linked, unquote, to the performance of the tasks the worker has to do. The case then went back to the UK Employment Tribunal, this decision, and here we see the tribunal consider the application of the regulations and whether those regulations can be interpreted so as to give effect to the EU directive. The literal interpretation of the Working Time Regulations provides for workers to be paid their basic salary as holiday pay, save only in limited circumstances. One circumstance is where commission is paid in connection with productivity, but not where the commission payment is made in connection with success, as Mr. Lock's was, so a successful sale, for example. The ECJ held that the Working Times Regulation exclusion was contrary to the EU directive, which provides for normal remuneration to be paid as holiday pay, such that the worker is not dissuaded from taking annual leave on the account that he'll suffer financially if he does so. And this case follows a string of recent cases on the topic and sees the Leicester Employment Tribunal follow the approach taken in the recent EAT case of Bear Scotland, which we've talked about on a previous podcast. And frankly, it's entirely unsurprising that it did decide that the regs could be applied consistently with the EU Working Time Directive. Just to put this case into context, quick reminder, Mr. Lock was employed by British Gas as a sales consultant, got a basic salary and commission by reference to the level of sales he made. The amount of commission far exceeded basic salary. Mr. Lock's claim related to holiday leave he took during Christmas 2011, during which time his pay included basic pay and the commission which he'd earned in previous weeks, but not any commission during the period of leave. Given that he was not carrying out any work during his holiday, he was not able to make any new sales or follow up on potential sales during that period. Accordingly, he was not able to generate any commission. And in the light of his inability to earn commission during his annual leave, his remuneration following the time he took off was considerably reduced. Mr. Lock consequently brought an Employment Tribunal claim arguing that his holiday pay should reflect his commission earnings as well as his basic salary, and the rest, almost, as they say, is history. Well, the Employment Tribunal originally stayed Mr. Lock's case, referred it to the ECJ, who determined that commission payments had to be taken into account, and then remitted the case back to the UK Employment Tribunal to decide the method of calculating the holiday pay payable, which meant calculating the commission payable to workers in respect of annual leave. Ah, how fantastic. Almost at the end of the podcast. As expected, particularly following the EAT's judgment in Bear Scotland, where the EAT determined that the UK regulations should be interpreted in line with the directive, such that non-guaranteed overtime form part of a worker's holiday pay entitlement, here the tribunal in this case similarly concluded that the working time regs should be construed in accordance with the EU directive from which it derived. Now, the Employment Tribunal had to get past the case of Evans and the Mali organisation, where the facts were, in broad terms, identical to those of Mr. Lock's case, and the Court of Appeal had said that the commission payments in question could not be included in his holiday pay calculation because of the relevant UK legislation. The tribunal in the Locke case concluded the position under UK domestic law, as taken by the Court of Appeal in the Evans case, was, quote, diametrically, unquote, opposed to the position under EU law. As such, the tribunal concluded there could be little doubt that Evans is no longer consistent with the emerging jurisprudence on holiday pay, following cases such as British Airways and Williams, and now Locke. And so the English statute, which says that the interpretation of a week's pay means that they do not receive normal remuneration during periods of annual leave, based on things like the Evans case, this approach cannot be supported under EU law. So this employment tribunal considered it could see no difference in principle between pay in respect of non-guaranteed overtime and pay in respect of commission, stating are just two types of normal remuneration and are really two sides of the same coin so far as annual leave pay is concerned. The arguments made by British Gas in this case were considered to have already been the subject of judicial consideration in Best Scotland, and the fact that Locke considered the issue of results-based commission and Best Scotland considered non-guaranteed overtime was really irrelevant. Tribunal held that a conforming interpretation was necessary so that the working time regulations could be interpreted in a manner which gives effect to EU law, and consequently that, quote, commission or similar payments, unquote, must be included when calculating a worker's holiday pay. Now, the tribunal read those words into the working time regulations. Well, the decision itself is perhaps unsurprising, but it leaves a considerable number of issues undetermined. For example, would the tribunal and the ECJ, for that matter, have come to a different decision if the commission payments had been infrequent or significantly lower in value? And although the tribunal determined that Mr. Locke's holiday pay should have included an average of the commission he earned, the issue of what exactly constitutes commission for these purposes remains unanswered. The additional wording inserted into the working time regulations refers to, quote, commission or similar payments, unquote. And the concern for many employers is this could be interpreted to include discretionary bonuses, particularly those tied closely to the volume or value of business produced by an employee. It's also interesting that in this case, British Gas argued that it had a commission scheme that was already structured to account for the commission element of holiday pay, and as such, Mr. Locke had been compensated for his annual leave. And therefore there was no unlawful deduction in respect of holiday pay. Now, this issue of quite how the commission scheme works at British Gas was not addressed by the tribunal and will be addressed in a subsequent hearing. Equally, the tribunal expressly avoided the issue of how the commission element of holiday pay is to be calculated and the reference period. At the moment, their wording would seem to indicate that the reference period for calculating that average will be in the 12-week period preceding the holiday in question. A 12-week rolling period would be an administrative nightmare for employers with large workforces who earn commission. It's also unlikely to be a representative calculation in a business where commission fluctuates during the year. As I've said on this podcast before, the combination of a 12-week reference period and discretionary bonuses being covered by the working time regulations holiday pay calculations would have a catastrophic result, and employees who were on the calendar year bonus schemes would find suddenly that everyone was trying to book holiday in January and February. It may, of course, be the case that if it's a truly discretionary bonus scheme, employers simply start paying that bonus award over 12 equal monthly instalments to avoid that sort of arbitrary fluctuation in pay. Then the bonuses could be reduced by a sufficient percentage that when you add back in the obligation to pay holiday pay, you're back where you all started. Well, I suppose it all makes work for the working man or the working lawyer to do. The other point, of course, to mention before I leave this case is that employers will, of course, have very much in mind that the 2-year limit on unlawful deduction of wages claims is being introduced from 1 July this year, and that's going to cap the opportunity for back pay claims. So, that's the case of Locke and British Gas Trading Limited. Just wanted to mention 3 other quick points. First of all, the podcast with Liz Stern talking about global mobility is going to go out next week. And so please do keep an ear, eye, whatever, open for that. It's a really good podcast. She makes a number of really interesting points. It's well worth listening to. Secondly, do take the time to follow up our YouTube offering, the YouTube version of this podcast, because sometimes it's easier for individuals to access our podcast series through YouTube than it is via iTunes. And finally, and of course, I can happy to confirm that no employees were harmed or otherwise mistreated in the making of this podcast, as always. Thanks very much indeed, and until our next podcast series, take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.